Hello everybody and welcome to today's Bristol Law Society webinar. I'm Ben Holt, immediate past president of Bristol Law Society and a commercial litigation partner at VWV. I'll shortly hand over to today's guest speaker, Mark Beaumont of Annecto Legal. Annecto Legal are one of the UK's leading commercial litigation funding and ATE insurance brokers, and as we're all hopefully aware, advising clients on funding options is a very necessary part of our early advice. Perhaps more importantly, I've known Mark and his colleague David Law at Annecto for many years, and they're both thoroughly nice chaps. So do pick up the phone if you've got any queries. I'm sure they'll be delighted to have a chat. They've also been really great supporters of Bristol Law Society for a long time, so thank you, Mark, for that. Mark's going to talk to us today about security for costs applications and responding to them, which can of course be a very significant strategic consideration in dealing with claims where the claimant may not appear to have huge resources. We're going to be recording the session today, and it's going to be available on our YouTube channel, so if you've got any colleagues who were unable to attend, the link will be sent out and shared. If you have any questions to put to Mark, please make them as difficult as possible, and put them into the Q&A function at the bottom of your screens, and I'll read them out anonymously unless you particularly want to be named. Before I hand over to Mark, if I could just do a quick plug for the fantastic upcoming webinars. On the 7th of June, we've got a law firm succession planning for the future roundtable. On the 15th of June, we've got a regulatory talk with Albion Chambers. On the 29th of June, we've got a property litigation talk with Gatehouse Chambers. And on the 6th of July, we've got e-scooters, a wobbly way forward with Patrick West of St John's Chambers, will be particularly relevant for personal injury practitioners. And that seems fairly likely given how terrifying they look within Bristol is what I've seen. Also, even more excitingly for me, the quiz is back. On the 23rd of June, I will be hosting our first Bristol Law Society quiz, I think since pre-lockdown. So that will be exciting. So look forward to seeing you all in person there. And hot off the press, the 14th of July is going to be the date for the Bristol Law Society summer party. So again, hopefully see you all there. So without further ado, I shall hand over to Mark. Thank you.
Thank you, Ben, for the kind introduction, and I think Ben's deliberately stitched me up there asking for very difficult questions. I was just explaining to him that my flight yesterday was somewhat delayed, so I only got home at 2:30 this morning. So in addition to this disclaimer from the legal side, my second disclaimer is apologies if it is somewhat laboured. It's not intentional. What I would say as well is security for costs is quite a broad subject. So I appreciate that for some of you, parts of this will be kind of beyond your experience and perhaps you're learning things new. For others, I'm sure this is more than familiar, and I can only apologise. I'm obviously trying to pitch this to a fairly wide audience. As Ben said, you're more than welcome to chip in with questions as we go along. I think they're being collated. And they'll be asked at the end of the session if they haven't already been dealt with in later slides. And if I can't actually deal with them, either through lack of knowledge or pure tiredness, I will make sure that we go away and find an answer for you and come back with that. So, without further ado, we're going to cover a range of topics today. So I've got a slide just covering the absolute basics, and then we go into the CPR and how that deals with security for costs. What are the requirements and conditions, and then how you approach things like counterclaims, actually making an application, what levels of security is a court likely to award, and then how we deal with the practicalities around things like payments into and out of court, and of course some of the tools available to help you to deal with security for costs application, whether that's ATE insurance, particular different forms of insurance, some of the pricing around that, and then things like deeds of indemnity as well, and how they can be used as a cost-effective tool to manage security for costs applications against your clients. So on we go. I would say as well, my preference doing a talk is, number one, to do them in person. I think it's nice to be able to see the room and for people to be able to ask questions as we go along. I find that quite helpful just to break up the flow a little bit so you don't have to hear my voice continually. The other thing I like to do is to have limited information on the slides, so that the talk itself is a bit more engaging and I'm conveying information that's not just written down there in front of you. With this being online and the slides being circulated afterwards, I have tried to include a lot more information actually within those as well. So apologies if I'm reading out a lot of this. I will be trying to add other information that's not available on the slides as well, but just to explain the kind of format a little bit. And the aim with this is to, I think, look towards a wrap up around about 10:45, with time for questions on the end. So looking at the real basics here, obviously, you know, the issue around security for costs is all about people defending claims, businesses defending claims, where they feel like the claimant that's pursuing the claim just doesn't have the funds or the resources to be able to satisfy any kind of costs award if it's made against them at the end. So they're confident in being able to defend the claim, don't think the claimants have got the money to be able to pay those costs. That's the standard for obviously security for costs. The other thing to think about as well, and what we're seeing a lot more of, is people making real tactical use of security for costs. So really using it as a way to make it more difficult for claimants to pursue claims, and trying to put hurdles in the way, claimants bringing claims against a defendant, or indeed trying to create challenges around the relationship with, say, the after the event insurer or the litigation funder that might be sitting behind the claimant. So definitely a lot more kind of tactical games being played around this area than we saw many years ago. CPR 25 is obviously the main section that deals with security for costs, although there are other areas that touch on it too. And what this all means is that the rules allow the court to order a claimant to pay security for costs where there's a significant risk that the defendant will suffer the injustice of having to defend a case, but no prospect of being able to recover their costs. It will not usually be ordered where there's a set-off, as that's considered to be a defence rather than a claim itself. But it's dealt with differently in the context of a genuine counterclaim. Some of the considerations that are going to apply where a defendant's brought a counterclaim. Let's say there's coextensive claims, and there's so much going on, it would just be unfair, really, to order security for costs in the circumstances. It could be that there's a funder sitting in the background of the claimant, and a security for costs can be sought from them instead. We can look at issues where it's clearly just a stifling technique, and I've seen arguments brought by claimants where they've successfully argued that defendants are simply trying to stifle their claim and no more. And you can look at other issues as well, such as would it be, you know, a breach of human rights to stifle a claim on the basis of security for costs. SFC is obviously security for costs all the way through this. I've just abbreviated it. I'm going to try and make an effort not to just read out every single word on these slides. These three are the threshold tests really for the court. So is the court satisfied, given all of the circumstances, that it is just to make an order, whether the conditions in CPR 25.13 have been met, and whether an enactment permits the court to require security for costs. So they're really the three threshold tests, and the court cannot exercise its discretion to make an order if they're not met. Some of the examples of conditions which would need to be satisfied. So the claimant could be resident outside of the jurisdiction, or you as defendants believe that the claimant company to be insolvent or impecunious. Has the claimant recently changed address or failed to provide an address, or taken any steps in terms of its location, the location of its assets, in order to make it more difficult to potentially enforce a cost order. These are all things that can be considered. There is actually a great deal of case law around these particular issues, and I'm not going to get into all the depth of that now because it really is extensive, but there's a lot of guidance and advice within there when you're considering these conditions and steps that you need to take. One of the interesting areas is around counterclaims. So obviously there are issues that arise as to whether the claimant can obtain security for costs against a counterclaiming defendant, or whether indeed a counterclaiming defendant is able to seek security for costs against a claimant. So as always in law, it depends on the specifics of the circumstances, but some of the things to consider here are going to be whether there's a disparity or an overlap between the claim and the counterclaim, and what the merits of the counterclaim are, and whether it's essentially a cross-claim or whether it has independent vitality of its own as a kind of standalone claim, if you like. With regards to this latter point, we come into the Crabtree Principle, and that's something I'm going to explain on the next slide. So, as a general rule, the courts won't order a claimant to provide security where the defendant's pursuing a counterclaim which requires examination of the same issues. And this is what's referred to as the Crabtree Principle. And this is from Crabtree against GPT back in 1990, 32 years ago, my goodness. Where the claim raises substantial factual inquiries which are not the subject of the counterclaim, it might be appropriate for the court to order security. But it will generally be limited to the costs of addressing those additional issues. So as you can see, that's very specific to what the courts are actually going to consider in those circumstances. Okay, so that's a bit of background, getting into more the kind of the practicalities really. So typically, the later you leave an application for security, number one, the harder it's likely to be to get security. And number two, the less security the court's likely to allow. So it's important to consider, if you're defending a claim, consider very early on whether security for costs is something that you either need from a defense perspective to protect your client's position. You're concerned that you've got a good defense here, but the other side might not be good for the costs. Or the kind of secondary reason, which is, well, this wouldn't be on your application, but you think a security for costs application is a good tactical tool to use in the litigation in order to make life difficult for the claimants. The typical stage where applications are made for security is going to be around CMC. It doesn't have to be there, but that is where they're most commonly made. It may be that you get a significant way into the case and then things start to develop in a fashion that make you think now is a time where security is required. So it could be that the claimants have started to take steps to move assets out of reach. The business that's bringing the claim potentially is hitting some kind of issues regarding solvency that you've become aware of from public knowledge, or perhaps from keeping an eye out in the business press, or having other kind of solvency tools, if you like, that are monitoring the claimant business and flagging up that there are issues around payments, perhaps. I know there are tools such as red flag alert and various other things that businesses use from time to time. Another opportunity to consider security for costs might be if budgets are escalating significantly, where you get the impression that the claimants are really trying to spend money bringing lots of different applications to make life difficult for the defendants. It might be a time to consider a security application at that point. You don't immediately make an application, so you should write to the other side first. If they're not willing to comply with the security request, at that point, you can use your letter and their response as part of your submission in accordance with CPR 23 to the court. And when making that application, consider whether it's appropriate to include any undertaking to compensate the claimant as well. You don't have to, but it may be something that makes it easier to actually get security for costs. On the flip side of that, as a claimant, if a defendant does bring a security for costs application or writes to you with the intention of doing so, consider whether you should be requesting at that time for them to provide some kind of undertaking around what it might cost you to provide security. It's certainly a conversation worth engaging in. No guarantees the court will allow. The party that's actually looking for security will need to show that the level sought is appropriate. The courts will typically consider all of the circumstances of the case, but in particular, it's going to be things like, what are the budgets? What's likely to be recovered as a portion of the budget? So, is taking a third off the budget an appropriate amount to provide security for? Also, it might not be necessary to provide all of the security in one go. It may be appropriate to provide a more staged solution. We'll look at that in the next slide. The court will also consider the other side's ability to actually provide the level of security sought and whether what you're doing is reasonable. Obviously, there's very few cases now where CFA success fees are still recoverable, but in those rare circumstances where they are still allowed, the court may consider the uplift as part of the security as well. Where there's a real risk of non-enforcement, that will be a relevant factor, or certainly can be from a court's perspective when determining the levels. And as I say, staged or part payments, so working up to perhaps key parts of the litigation process, is a good way of thinking about security. So if the defendants are asking you for, say, £300,000 security all the way through to a final hearing, it may be appropriate for you as the claimant to offer up, say, £50,000 or £100,000 security to take you up to, say, I don't know, beyond the CMC or perhaps a latter stage of the hearings, with a view that you can then provide additional security in tranches as you go along, with a view to the entire amount being provided if you're heading towards trial. This should satisfy the needs of the defendant, but it should also make the costs more manageable from the claimant's perspective. So typically things can be agreed there. And that's whether you're providing cash into court in a kind of traditional way of providing security to the defendants, or that can be providing a kind of tranched insurance or funded product that meets the security needs. But it will be a rare circumstance, I think, where you'd want to provide the entirety of security just on day one, unless you think there are tactical advantages to kind of showing your hand, if you like, and showing the defendants that you're absolutely solid, you've got the money, you're there for the long game, and you're not quibbling about details. That might be the way you want to play the litigation, just purely from a tactical point. Once an order has been made for security, it doesn't mean you can't change it. There can still be arguments later on to increase or decrease the level of security, depending how the litigation evolves, how budgets are changing, whether other elements are being brought into the case, the case is expanding or contracting, perhaps issues have been dealt with and therefore the budgets are decreasing at that point, and security can be reduced as a consequence. It may be that the claimant wins on certain points early on, perhaps in a strikeout hearing, which means that they've protected certain elements of the costs. It's unlikely they're going to lose on everything, and perhaps the level of security could be reduced at that point. Things of that order are worth considering. The actual practical process for payments into and out of court is that you do need to notify the other side when payments are made. So that the payments are actually made into the court funds office and they're held there. You inform the other side that that payment's been made. If a payment is to be made out of the court funds office, it's generally done through a court order. So either there'll be some kind of costs award or the case will be dismissed, but there'll be something that happens that allows for those funds to be distributed. And they will obviously be distributed either across to the defendant to cover a costs award, or partly across to the defendant if the security provided is too large, with the remainder coming back to the claimant. But it will generally all be done through court order and through applications made into the court funds office. Just a final point there, an application can be made by the defendant for the payment of any surplus funds to be made to the defendant in full or part settlement of any judgment. So that's not for use as actual costs itself. And that's something worth bearing in mind if you're going to lodge cash with the court. So traditionally, cash has been the tool that's been used to satisfy security for costs. But if you go way back to the 1800s, there was case law that said that insurance or a bond from a first-class London bank could be used in lieu of cash to provide security for costs. Obviously, we've moved on somewhat from bonds from banks, and after the event, legal expense insurance tends to be a more typical tool used these days. It was used very successfully for a number of years, and then was challenged in Premier Motor auctions 5 years ago. And that led to some kind of tweaks to how security to how ATE insurance policies were perceived in relation to security. So that particular case challenged on the grounds that the policy could be voided if the applicant was shown to have been fraudulent on their application for insurance. So just as in the same way as if you lie about the types of locks you have on your front door, or having a fire alarm or a flat roof in relation to your building insurance, obviously an insurer will look to void the policy. Exactly the same can happen with ATE insurance. So if there's been fraudulent misrepresentations made to the insurer to secure that ATE insurance, it won't necessarily pay out to the defendant where required. So a common argument brought by defendants is that that if they successfully defend the claim and therefore need the ATE insurance to pay out to them, the circumstances of them successfully defending the claim make it perhaps more likely that they will have shown the claimants to have not been truthful, and therefore it increases the likelihood the claimant has not been truthful to their insurer either, and therefore the ATE policy will not pay out to the defendant. So it's a kind of step-by-step argument that they'll use to try and show that should they actually successfully defend the claim, the ATE policy is not going to pay out to them. Now, a bit like talking earlier around the tactical reasons for bringing a security for costs application rather than just concerns about payment, there's similar games being played here typically, which is that a defendant may well be quite satisfied with an ATE policy, but if you've managed to get one, they might then consider that it's worth making your life slightly harder as a claimant and challenging the actual policy. Then you'll either need to go to court, argue the point, and say that the ATE is absolutely valid, or you'll need to have a negotiation with your insurer to see whether you can have those clauses removed. So they are typically referred to as anti-avoidance endorsements, which would need to be inserted into the policy, which means that the policy can no longer be voided. Sometimes they don't cover fraud, so the defendants will still be able to make similar arguments anyway. And it may be that you actually need to step up and provide a full deed of indemnity. So that's an irrevocable guarantee for payment directly to the defendants by the insurer or the deed provider. It is usually the insurer or the reinsurer. And it could be provided by a litigation funder or any other kind of suitably well-financed entity. So that's really around the kind of wording of the policy. Other things to consider, and this was also talked about in Premier Motor auctions, were that there were multiple insurers on that case because it was a high level of insurance that was provided. I think there were 4 insurers, and the court commented on the fact that the 4th insurer, the one picking up the kind of tail end risk, if you like, the last part of the insured risk, was based in Gibraltar. They weren't rated as A-rated, which is what you would typically look for in an insurer, and therefore there could be deemed to be some payment risk around that insurer. The court in this instance said that they weren't carrying enough of the primary risk for it to be a valid concern, but it did flag up that there's an avenue that can be explored there by defendants, which is actually looking at the rating of the insurer and where they're based. So things to consider when taking out a policy or when challenging the other side's ATE policy. Typically, a defendant will ask for sight of the ATE policy. That can be redacted. So any commercial information around pricing, for example, can be removed. But what it will have in there is obviously, any avoidance clauses, details of who the insurer is, and the defendants can do their own research about that insurer, where they're based, whether they're rated, what their rating is, etc., at their solvency level. Just on that, historically, ratings agencies have been the kind of go-to place to decide whether an insurer is satisfactory, both from a claimant's point of view of, are you happy with the quality of the insurance you're providing and that's going to protect your position, and also from any defendant challenges as well. There is an argument now that the BAL regulations around insurance and the UK Solvency II regulations, that they could be deemed to be just as important, perhaps even more so. So there are arguments to be had around there as well. But really, it all comes down to judging solvency and whatever arguments you want to put forward from either side about how that should be judged and what the correct answer should be. If you're saying that you need time to sort out security for costs, such as liaising with funders and insurers to obtain a policy, the court could ask you to provide some kind of interim measure to provide security to the defendants. More typically, the matter will just be stayed until that issue is resolved. If you have provided cash into court on a case and then decide that for whatever reason you'd like to get that cash back, so perhaps the case has gone on longer than you thought, or you need liquidity for your business, you could look to replace that cash with some kind of insurance policy. Obviously, in those circumstances where the defendant would in essence be kind of giving up cash in exchange for something else, I think it's safe to say that they'll look very carefully at the wording of your policy, and it's much more likely that you'll need to provide something like a deed of indemnity rather than just an ATE policy. I'd be surprised if any defendant would be willing to give up cash just for an ATE policy and the risks that come with that, as we've talked about in terms of avoidance. So from a claimant position, when your ATE policy is challenged, there are various steps you can take. But what I would say is, on any case where you think there's likely to be security for cost considerations, then it's worth considering at the outset what type of policy you are looking for and from what type of insurer. So, as an example, it may be that your client can get access to a very low cost insurance policy from an offshore insurer that's willing to do a fully deferred premium that's really good value from the claimant's point of view. And that might be their preferred choice. However, if you think there could be security for cost challenges further down the line in the case, it may be worth considering whether that insurance policy will actually stand up to those challenges, and whether you might actually be creating a problem there, in that if that insurer is not going to be deemed to be acceptable from a security point of view, and that insurer is unable to provide a deed of indemnity, you may be in an awkward position later on in the case where you need to provide some kind of additional insurance or a deed of indemnity from somewhere else against that policy. That can be very, very hard to do, because you're essentially going to another entity and asking them to provide an irrevocable guarantee of payment against somebody else's insurance policy, when they also might have concerns about whether that insurer will pay out or is creditworthy or whatever. It's therefore important, if you think there are going to be security for cost considerations, to look at getting the right insurer from day one, and perhaps even having conversations with them early on about what their approach to security for costs is. So what's their rating or their approach to how they deal with those questions around solvency? What's their approach to anti-avoidance endorsements? What kind of costs might they seek, or what kind of pricing might they charge to your client for providing those kinds of endorsements? Do they provide a deed of indemnity? What kind of costs might be associated with that? There's pretty standard market rates for deeds, around 10%, and we do cover pricing in a later slide. But I do know there are some insurers where their reinsurers insist on a 25% upfront payment for a deed. So if you think you're likely to going to get into an argument about security for costs, that might not be the insurer you want to go with early on in the process. If it hamstrings you later, you'll find yourself having to put a lot of money down, or your client having to put a lot of money down to pay for a deed of indemnity. As mentioned earlier, you don't have to provide, or you shouldn't have to provide all of the security from day one. You may choose to, maybe a sensible way of dealing with things, or it may be that you take a staged approach and either come to an agreement with the other side about when those stages should kick in and what the size of them should be, and how that matches up against their likely expenditure versus their budget. Or if you can't come to that agreement, you can always go off to court and get approval there from a judge as to how you provide the security and in what kind of tranches. It's a pretty standard thing to do now, particularly on larger cases where the amount of security can be very large. You can be talking about millions of pounds on a big budget case. You don't necessarily want to be providing all of that on day one, particularly if it comes with some heavy upfront costs to pay for the policy itself, any endorsements, perhaps a deed. And if those costs are being put up by a third-party funder, obviously there's a multiplier effect in the way that third-party funding is paid for that can make those costs really start to ratchet up as time goes on. So the more of this you can push further into the future, obviously the lower costs to your client, plus also they might never have to pay it if you can settle the claim. And it does create more opportunities for settlement if there aren't enormous costs to be built in, either for security or for litigation funders that are going to have to come out of any settlement agreement. Just one other thing here on the opportunities to void a policy. And this actually comes back to the Premier Motor auctions against PricewaterhouseCoopers. One of the arguments that was brought in that case by the defendants was that if the claimant had made representations to the insurer that would later show to have been completely false, knowingly false, then the insurer could void the policy. Where I think the claimants missed an opportunity there was that that case was actually being pursued by the liquidator of Premier Motor Auctions, not one of the directors or the owners of Premier. Therefore, the liquidator was relying on the witness testimony of the director and documentary evidence to, number one, pursue the claim, but number two, make representations to the insurer about what basis they were making that claim. It seems to me that, number one, the liquidator wouldn't have had any reason to lie and knowingly mislead the insurer, because the liquidator would obviously want to protect their own position in relation to adverse costs. You don't want to be personally liable for a piece of litigation you're bringing on behalf of creditors. Number two, they were relying on other people's witness testimony. If anyone was likely to lie in that scenario, it might have been a director of the business. But the liquidator would be relying reasonably on their testimony and wouldn't have knowingly made any false representations to the insurer. So I think where you've got claims that you're bringing on behalf of insolvency practitioners, consider whether you actually need to take those steps in relation to the anti-avoidance endorsements, or whether you can simply argue the point back to the defendants of there isn't really a circumstance where your client would have misrepresented the case to the insurer. It just wouldn't make sense for them to do so. And they're relying on other people's evidence. Sorry, I just mentioned that because it's still, I find it a bit strange that the defendants were able to bring and succeed on that point in a claim where it was brought on behalf of the liquidator. It doesn't really make any sense. So ATE pricing, some of you will be familiar with this, perhaps others less so, but ATE is not the same or isn't priced in the same way as before the event insurance. And by before the event insurance, I mean, you know, like household policies, car insurance, holiday insurance. You take out a policy on the basis that something may happen in the future and you want to insure against that risk. ATE is after the event. There has already been a problem and you're taking out a policy now to deal with the litigation around that problem. It's really quite different to before the event policy. I actually think sometimes it's easier to understand ATE if you think about it a little bit less like insurance and a little bit more like a kind of swap. So what you're doing is the claimant is swapping their obligation to pay the defendant if they lose with an obligation to pay the insurer if they win. So if the case loses, the insurer pays the defendant. If the case wins, the claimant pays the insurer. Now, there are some exceptions to that, which we'll go through here. But it used to be that pretty much all ATE insurance would be done in that way. So the claimant takes out the policy. They pay nothing to the insurer at the point of taking out the policy. The insurer takes on the risk for the adverse costs. So, for example, you know, if £100,000 adverse costs is an appropriate amount of cover that you think you might have to pay to the other side if you lose, you tell the insurer, I need £100,000 of cover. I'm not paying anything for it now. If the case loses, the insurer will pay up to £100,000 to the defendant for their reasonable costs. And the claimant will pay nothing to the insurer in the event of that loss. However, if the case wins, the claimant will then pay the insurer. The amount that they pay to the insurer will depend when the case wins or settles. So if it goes all the way to trial, the claimant might pay anything from kind of 40 to 70% of the insured amount to the insurer. So using our example of £100,000, it could cost the claimant anything from £40,000 to £70,000 to pay for the insurance at that stage. If it settles earlier, it might be as little as £10,000, £15,000. And typically, the price of the insurance will go up over time or during the phases of the litigation. So it becomes more expensive if you go all the way to trial. And if you can settle pre-trial, it's usually a lot less. And if you can settle very quickly, considerably less. So that's a kind of fully deferred and contingent premium where it's fully deferred until successful outcome on the case. And it's contingent upon you actually being successful. So you pay nothing if you lose. Some of you will be familiar with that model. The way the market for insurance has shifted over the last kind of 5 or 10 years post-Jackson is that it's much more common now to pay something upfront on a policy. So it may be that you pay 10, 15% upfront on a policy with the rest of it deferred and contingent until a successful outcome. And obviously you can settle very quickly. There won't be anything further to pay. But if you go all the way to trial, there could be a significant amount further to pay. All the way through to entirely upfront policies, which, I mean, it's quite rare for these to be used, but you could just pay outright upfront for an ATE policy. I say it's rare to be used because it doesn't often make sense economically for a client to want to pay out an irrecoverable cost on an ATE policy straight out the door very early in a case. We do sometimes see pay-as-you-go policies, and where they can be attractive is typically they cost a lot less than a deferred and contingent policy overall. On the downside, you obviously are actually paying out as you go along in the case. So a standard model for that might be, if you needed £100,000 of adverse cost cover, you might pay £15,000 to take the policy out, perhaps another £5,000 or £10,000 around the midpoint of the case, and maybe another £15,000 if it went all the way to trial. So the total cost there, if you got to trial, you could have paid out maybe 30, 35%, something like that, to buy the policy outright. So there'd be nothing further to pay if you were successful in the claim. And obviously, if you lose out, then the insurer will pay out up to £100,000 to the other side. So there's a mix, basically, of, upfront, just pay all out, pay as you go models, deferred and contingent, or as I say, a kind of hybrid where you perhaps pay something upfront and the rest of it's deferred and contingent. So they're the kind of most common forms of ATE insurance. If I had to commit, I'd say the hybrid model is probably the one used most in the market now. So where the client would ideally like it to be fully deferred and contingent, but the insurer insists on, say, 10 to 15% upfront. And so it ends up being a kind of partially upfront, partially deferred and contingent. You then come on to issues around security for costs and go, okay, well, great if the other side agrees to my ATE policy, but what if they don't? Well, that's when I say, I think it's important to have these conversations early on with the insurer or broker or whatever, to actually discuss, what would happen if this ATE policy was challenged? What's the rating? Where are they based? What's happened on previous challenges against their policies? Are there any court judgments, either in favour or against this particular policy wording, location of the insurer? What's the attitude in the insurer towards providing anti-avoidance endorsements? Is that something they would do as standard? Is that something you could actually get from the off, so that it kind of moves any arguments around security for costs out of the way very early? Is there a price for that? Is that price to be paid up front, or is it something that can be built in to the deferred and contingent element of the claim? Again, these can be important factors to the claimant directly, but also to any litigation funder that might be involved in the claim. And finally, deeds of indemnity. Anti-avoidance endorsements can sometimes be paid for on a deferred and contingent basis. Not always, but sometimes. I've never seen that with a deed of indemnity. There's a pretty standard market rate, which is to have a deed of indemnity sit alongside or behind your ATE insurance is generally 10% of the amount of cover needed. So if you needed £100,000 security, the deed would be £10,000 up front. There are one or two insurers that charge more than that. As I say, there is one in the market that's typically charged 25%, which is a lot. Rare you see that done on a fully deferred basis. I'm not going to say it's impossible, but I don't think I've ever seen a deed of indemnity done on a purely contingent basis. There's generally something to pay up front on those. So things to think about from the defendant's point of view, areas where you can challenge. Again, it's the same things really. Are they rated? Are they onshore or offshore? Are you looking for anti-avoidance endorsements or deeds of indemnity? Thinking about it from the point of view of you want to make sure that your defendant is going to actually be paid if you're successful in defending the claim, but also from a tactical point of view, what's easiest or hardest for the claimant to secure. So by accepting an endorsement, are you actually potentially making life quite easy for them just to provide an endorsement to the policy? That's potentially something they could get for free, or potentially by adding something onto their deferred and contingent element of the premium. If you're pushing for a deed of indemnity, you can be pretty sure there's a kind of hard cost to that. And also, they're going to have to get that approved by the insurer. So it might be harder for them to actually do. And that could have knock-on effects in terms of their budget, their litigation funding budget. And they're going to have to make some hard choices around, Are they going to spend the time and money arguing with you and potentially going to court saying that the ATE policy is good enough? Or do they just go out and go, look, let's not spend the time and money doing that. Let's spend the time, the money actually securing a deed of indemnity or avoidance clause. And I think my voice has just about made it to the end of that. So we'll save some time for questions. I think there's a few that's popped up in the chat there. But just as a very final point, obviously we're brokers. We deal with a wide market here in terms of insurers and different products and what have you. I think a big part of this, and something Ben mentioned at the outset, you know, we've all got a duty to our clients here around letting them know what options they've got available to them. And that's really what we want to be able to do with clients and for you guys, is just let people make informed choices about how to deal with these kinds of issues. I will hand back to Ben.
Thank you, Mark. That was great. Just looking at the questions you had in, I shall read them out. First up, first question. My understanding is that there's no obligation on claimants to provide evidence of CFA or ATE funding now. So defendants may be making applications blind to the fact that their costs are potentially covered. Are there any tips you can give to try and tease out how a claimant is funding litigation in circumstances where they seem unable to afford it prior to making the application?
Yeah, so I guess, yeah, I mean, you're right. There's no obligation to inform you of how a case is funded because it doesn't change any of the adverse cost liabilities for the defendant. So the reason you used to have to fill out, was it N251, if I remember correctly, from 10 years ago, is because if you were using a CFA and ATE insurance, you'd be seeking to recover the premium and the success fee from the defendant. So it was only reasonable the defendant would be aware of that. Given that you can no longer recover them in the vast majority of cases, there's no longer any reason why the defendant needs to know that they're there. I guess the only real thing you can do is, other people may have thoughts on this as well. This is where it can be useful sometimes to be in a bit more of a live setting and other people can chip in. But my main thought there is just to write to them and say, look, you know, you're going to be seeking security for costs because you have doubts about their solvency, their ability to fund this litigation and what have you. You know, how would they deal with providing security? Is there something that they can agree to out of court? If not, you'll be making the application formally. I'm not sure, as I say, other people might have thoughts, but I'm not sure what else you could do really.
No, that's what I was thinking in response to it. But I mean, presumably, if you're faced with that application or a threat of the application, and you know you've got the insurance in place already, which might defeat it, it's going to be in presumably everyone's interest to tell them about it. Albeit, what's the insurer's attitude usually? Because on some, certainly some BTE policies, the insurers don't want you to let them know that it's insured. It might be one of the terms to say, don't mention the insurance. Are they more inclined, given the additional costs that are going to be incurred in dealing with the application, are they more inclined to allow you to mention it? What's the standard terms look like?
But BTE is slightly different. I mean, it may be the only way. If you were providing security for costs under a BTE policy, it's probably not good enough, frankly. There's probably not enough in there just in terms of the amount of costs that the BTE insurer would pay out to actually meet a security for costs application. That won't always be the case, but that's probably commonly a situation. ATE insurers, they're aware that if the other side's threatening security for costs, you're going to have to either, well, you're going to have to negotiate with them. So the first step would be to say, look, I've got an ATE insurance policy. You don't need to make an application for security. I'm sure the defendant at that point would say, great, show me the policy. An ATE insurer there would typically say, okay, you can show them, but remove any commercially sensitive information. So that really is usually just pricing at that point. So you'd send over a redacted version of the policy. The defendant then typically will come back and say, well, there's avoidance clauses here. So, you know, they'll run all the arguments I mentioned earlier around, well, if this and that happened, then the policy doesn't pay out. We don't think this is good enough. And then you can negotiate with the insurer and say, well, what if we get anti-avoidance endorsements? The other side may agree to those, or you might need to go full deed of indemnity at that point. Yeah, I can see, I mean, BTE insurers, yeah, are just a difficult beast to deal with at the best of times. So you might have very different issues where you're talking about sharing their policies. I can see.
But with ATE, they're more inclined to not necessarily sharing the policies, but allowing you to share the fact that they are in place.
Yeah, so they'll let you share the fact that it is insured, and often these days you will just have to share the policy because the other side's going to make all those arguments run in Premier, which really gets into the details of, you know, when does your policy respond, and more importantly, when will it not respond? Because if I, as a defendant, am concerned that your policy won't respond in the event that I win this claim, because essentially my argument is, if I win, I'll have shown you to be a liar, and therefore the insurer won't pay out. You know, that's a pretty common argument now. So you have to share the full policy, as I say, kind of commercially redacted, and that's when you get into the back and forth around the detail, and then you have to go for the endorsements or a deed usually. I mean, it's a pretty standard kind of back and forth on these things now.
Thank you. Next query we've got up. Presumably an ATE insurer will generally require an opinion as to the merits of the claim. Is that cost of obtaining the opinion something that the insurer will generally pick up, or will the insurer generally require the claimant to pay for that opinion?
Yeah, so almost always, I say almost because it's not in every single case, but almost always you'll need some kind of opinion on merits. Now, it may be that the solicitor is very specialist in the particular area of law. It may be that the case is relatively straightforward on the law, and it's not necessarily to go to specialist counsel to get a detailed opinion on the merits. So that's a possibility. You know, not every case is really heavy on the law, you know. On the cases where there's clearly legal issues to be argued, they probably will want an opinion from counsel. And typically 60% is a threshold there, whereby that's often what insurers have agreed with their reinsurers. So they won't back cases where prospects are less than 60%. So it's worth having the conversation with, you know, counsel before they put anything in writing of what's it going to say. Because what you don't want is an opinion on your case at 50–55%, because you're going to have to share that with the insurers. So better to not have it at all, frankly, than to have that on the file. What I often say is, you know, it's frustrating to have to spend money on something that you're going to use once and then throw in the bin. And that's kind of what an opinion on merits is going to be. So it can be more cost effective to say to counsel, you know, particularly where you're going to engage with counsel to say, assist with a detailed letter of claim or drafting the full particulars of claim, is to say to counsel, look, you know, you're going to spend the time reading into the case and preparing this with us. Could you do that? And then alongside the particulars or the letter of claim, just provide a short note that addresses the merits. That might be something that's of more value to the client than just going out and spending cash on a standalone opinion on the case. No is the answer in terms of insurers picking up this. They would expect the client to be doing the work on their case to see whether or not it's a good case. And it won't always just be an opinion on merits. It could be, you know, where there's a fully deferred and contingent premium, it may be that the key issue the insurer is concerned about is the assets of the defendant. You know, how are you actually going to get paid on this? We believe you've got a good case. We can see that. We're not. What our real concern is does the other side have any money? Because otherwise, how are you going to pay for this if you win? Or it could be more around causation and loss. What they might want to see is a more detailed forensic examination of the losses and how you're going to justify those, because unless there's a significant loss in the claim, potentially there's no funds there to actually pay for the insurance when the case wins. So yes, probably on the opinion on merits, but hopefully I've given you some ideas there of how you can maybe do it in a cost-effective way. But it's always worth having the conversation. I always say to people, look, we're happy to have a chat through a case fairly early on. If a client's got a limited budget, you know, it can be useful to have a conversation very, very early about, okay, where should that money be spent? Because if you are going to need insurance or funding or both later on, you want to use that very small pot of money to do the things that are going to be necessary to then be able to get the case underwritten. You know, it's frustrating to spend all of that money, you know, trying to settle the claim, if you like. That doesn't work. You've then got no money at all to do any of the tasks necessary to satisfy an underwriter.
Thank you. I'm sure the a lot of that will be very welcomed by the asker of the question, who's one of our friendly barristers, who will no doubt be very keen to provide those such opinions. That's the end of the questions on the chat thing, but just sort of an observation from me. It's not really a question, it's just an observation, but I've seen a couple of cases where opponents have got AT insurance, but the limit of the cover has been, I mean, just ridiculously low. I mean, I think one of them, it was sort of £25,000. It's just not going to be anywhere near enough. Almost any firm, I mean, certainly a large commercial firm, but you know, almost any firm I think would struggle to take a case all the way to a trial, particularly on a case where the other side had decided to issue it in the High Court. It just seems bizarre.
Yeah, I agree with that. My only thoughts there would be whether they perhaps thought they could chance their arm by saying we've got ATE and hope the other side don't ask too many more questions, or whether they were trying to pull a bit of a fast one there with the insurer and go, look, we only need a low level of cover, but then look to kind of scale it up as they go on. And that can annoy insurers. So there's a bit of a balancing act there, because, you know, if you think a case has got a really good chance of settling, you perhaps don't want an enormous insurance policy that's going to take a huge chunk out of any settlement when the time comes. But equally, what an insurer won't like is you massively underinsuring the claim and then seeking to hugely increase it further on down the line. And there's no guarantees at all that the insurer will agree to that. In fact, it's much more likely that they'll refuse to, in my experience. Yeah, so there is a bit of a balancing out there. But I think, you know, a lot of these things can be dealt with by just being open and honest and having a proper conversation with the insurers or brokers or whatever early on in the case of what you're trying to achieve. Because if everyone's on the same page, you know, and you can come to a kind of commercial agreement with the insurer about how to stage this, make it work cost effectively for the client, typically there's a solution that can be found. Where insurers get annoyed is when they feel like they're the ones being kept in the dark and manipulated, or things are being done, you know, that they're not quite aware of why. If you just have an open dialogue with them, often these things can be sorted out quite easily. And that would be just another thing as well, just to keep them updated during the case. They want to know what's happening. They don't need to know everything all of the time, but equally don't take out a policy and then say nothing to the insurance company for like a year and a half, and then go, we're at trial tomorrow. That will be a problem. And you'll probably be in breach of the conditions of the policy at that point as well. So just kind of general, regular-ish updates are helpful, just so people know what's going on.
Thanks, Mark. Well, I'm aware that we've just gone over 2 o'clock, so it's probably time to wrap it up. But thank you very much for that. That was brilliant as ever. And we'll no doubt welcome you back at some point later in the year or next to do another session. But on behalf of Bristol Law Society and all the participants, thank you very much.
Pleasure.
I'm going to go off and get some lunch.
Thanks, guys. Cheers, everyone. Bye now.